Good morning and welcome to the Tennessee Court of Appeals. Before we get started, I want to, first of all, introduce the panel and then go over a few ground rules about what we're going to do and how this works. First of all, I want to thank each of you and your clients for agreeing to participate by Zoom. I know this is not the norm, or maybe it is the norm now, I'm not real sure. But it's not the way we like to do things, but it's the way we have to do things to keep everyone as safely as possible. Your panel this morning will be Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. I realize we've got two experienced practitioners, but just to make sure everybody knows what we're doing, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you introduce yourself and before you begin your oral argument. Obviously, appellee gets no rebuttal time. Want to thank Mr. Jim Hivner and Ms. Angie Dempsey, who's the deputy clerk, for putting this all together and making it work for us, as well as the AOC technology staff who have been tremendous, because left to our own devices, we would not be doing so well. With all that having said, Ms. Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
Phillip Mahnken versus Andrew Bettis, Aviation, LLC.
We'll hear from the appellant.
Good morning, Your Honors. My name is Billy Ryan, Shelby County, Tennessee Bar. Represent Andrew Bettis Aviation. They do business as AB Jets, so you'll hear me refer to them as AB Jets throughout. I'd like to reserve 3 minutes of rebuttal, please.
3 minutes. All right, sir, you may proceed.
This is a breach of contract case brought by Mr. Mahnken against AB Jets. We're arguing over 30 days of notice pay. As you saw in our opening brief, Mr. Mahnken was employed as a pilot with AB Jets. They're a charter jet service company based out of Memphis, commercial flights. They do a variety of things. They'll fly a country music star. They'll fly somebody who just has a lot of money. They'll fly corporate travel. They'll fly transplant flights for Vandy and Methodist. I tell you all that in context because Mr. Mahnken, you'll hear from him, his attorney, make the point that he was always physically able to fly, but the proof was uncontroverted at trial that AB Jets would not allow Mr. Mahnken to fly, given his physical health status, his sickness, if you will, that he announced to them during the termination meeting.
What does that mean, Mr. Ryan?
Well, Tennessee law is clear, Your Honor, and there's the case that we cite in our opening brief says it far better than I could. Jenkins Subway versus Jones. If you have a personal service contract, and there's no doubt about that, you've got to be able to physically do the job or the other party's excuse from non-performance. And I will quote, contracts to perform personal acts are considered as made on the implied condition that the party shall be alive, A, and B, capable of performing the contract so that death or disability, including sickness, will operate as a discharge, termination of the contract, or excuse for non-performance.
And what did the trial court find about that?
The trial court finding really was unclear. It almost dodged the specific question as to whether Mr. Mahnken, when he quote, I'm going out on workers' comp, would have been physically able to perform his job as a pilot, as a commercial pilot over the next 30 days. In fact, Mr. Mahnken's by his own proof, by his own testimony and the exhibits that we entered into the record, he was on light duty for a portion of that 30-day period and wasn't released to full duty until October 30th. And so he was never at full duty during the.
When was your client aware of all that?
Well,
I thought there was something in the record that indicated that he didn't even go to the doctor until after he had been, I guess, terminated.
Right.
Am I wrong
So,
about that?
Well, the timing's just a little bit off. Here's exactly the way it went down. There was a termination call, and it's undisputed that they had made the decision internally, instead of firing him for cause, which would have given them the ability to avoid having to pay altogether unless he sued for it. They decided to terminate him without cause. Now, the 30 days of notice pay would have been paid, but for, this is critical, Mr. Mahnken's own testimony in the termination call before the termination had effectively been announced, that he was going out on workers' compensation. At that point,
What does that mean?
At that point, he's saying, I'm physically unable to do the job. There's no other way you can parse that. He is saying, I'm physically unable to do the job. I'm, quote, going out on workers' comp. If I say that, if anybody else in Tennessee says that, then the remedy is workers' comp benefits and not continuation of your salary. When he says, I'm going out, it's his obligation at that point to go to the doctor or to avail himself under the workers' comp remedies, which he did. He went to an authorized treating physician. He went to Dr. Sam Merle, who did testing, who evaluated, who diagnosed him, and ultimately released him to full duty on October 30th. So respectfully, I think where the trial court erred was she was worried about what was in AB Jet's head, whether they knew or should have known, or how that would have impacted their ability to have to perform under the contract. That's the wrong analysis. It starts and stops with Mr. Mahnken. If he's not physically able to perform his end of the deal, then AB Jets is excused on its side from having to perform. That's a hallmark of a person.
Correct me if I'm wrong.
Yes.
Did not the trial court find that he was physically able to perform his job?
I don't think that she found it that clearly, but if she did, that was clear error by Mr. How could she make that finding when he said he was going out? How could she make that finding when the medical records that were entered indicate that he was at not full duty? How could she find that when there was uncontroverted testimony by AB Jets, which said they wouldn't let any pilot fly a commercial plane, which would be carrying other human beings, if the pilot were not physically to perform all of the functions? And when a person says they're going out, I don't think it's certainly within AB Jet's right, within the FAA regulations, that pilot needs to be checked out and to be able to physically able to fly. And frankly, I think I don't know why Mr. Mahnken decided at that moment to say he was going out. It was almost like he was trying to beat AB Jets to the punch in some way. I can't get in the guy's head, but I know that that's what he said he did. And that in and of itself excuses AB Jets from having to pay him 30 days of pay when he wasn't physically able to do the job. So you look at it right then and there based on what he says. And so for the trial court to find that he was physically able, that would be disregarding pretty much all the record evidence, Your Honor, most respectfully. And I have respect for the trial court, but it's just, that's the reason why we took an appeal over $7,500.
Well, I found what I was looking for. It's in paragraph 8, second sentence. Plaintiff was not disabled when he was terminated, and defendant didn't advise plaintiff that it considered him to be disabled due to plaintiff filing a workers' compensation claim the day after he was terminated, and that it needed to get him a medical release to fly. Mr. Turner testified he had no intention of calling plaintiff in to work after his termination on September 20, 2018.
That's right. Yeah, that's right. There's David Turner of AB Jets was not going to call him back, particularly in light of the fact that he had said he's taken himself out. But let's just say that, God forbid, Mr. Mahnken whether AB Jets was going to call him into work during that 30-day period or not. Let's say, God forbid, he just passed out and died right then and there. Whether they were going to call him back or not his death would still excuse their performance. The same thing with the sickness. Whether they were going to call him back and have him actually work during that 30 days, their performance is still excused by his physical inability to do the job.
That's my point, I suppose, in reading the trial court's finding, and the trial court seems to have specifically found he was capable of doing the job.
Which
is that the issue that you're, I guess, focusing on?
Certainly, it's a part of it. I mean, a court of appeals judges routinely, while given deference to specific factual findings, won't hesitate to overturn where clear evidence shows that the trial court erred. And so
what's clear evidence here?
The fact that he said, one, he's taking himself out of work and he's going to go on workers' compensation. Okay. Number two, the doctor's notes that are in the record never release him to full duty. Number three, AB Jets testified that per FAA rules and their own internal policies, they would not allow any pilot to work until they were released at full duty, given that kind of magnitude of a back condition. You don't want a commercial pilot with a bad back who says, they're going out on workers' comp to be able to fly your planes until they're medically cleared. And so the timing of it, whether Mahnken knew that or not, whether he knew the state of Tennessee law or not, and whether that was in his head at that moment, it's really of no consequence to the analysis. Why? The question really should be framed, did AB Jets have a basis under Tennessee law to refuse to perform its end of the deal? And that rests and turns on whether Mahnken was physically able to perform the job. And we just contend that the record evidence is overwhelming that he wasn't. If it comes out of his own mouth, I don't know what better evidence you need, but we do have adequate corroborating evidence in the form of doctors, medical doctors. He didn't test, he offered nothing from a physician that said he was able to perform. Whereas we offered evidence from physicians that he was not at full duty. You would think that there would be something that he would have offered that said, I wasn't. They knew what we were going to be arguing at the trial court. The reason why is they didn't have that evidence, especially when it came out of his own mouth that he was going, quote, out on workers' compensation. So I think it's just an application of the Jenkins subway case to these particular facts. And we do think the trial court erred to the extent that she found that he was physically able to fly as a commercial pilot during that 30-day notice period. Thank you.
Thank you. You still have your rebuttal time. We'll hear from the appellate. Mr. Caperton.
Good morning, and may it please the court. I'm Cole Caperton of the Memphis Bar, and I'm here representing Phillip Mahnken. Mr. Mahnken is a very experienced pilot, having finished his career at FedEx, flying a 777, which is a very large airplane. He went then to these small jets, and he's a bigger guy, and you've already heard the facts of his signing a contract, which he clearly did, and being willing to live by that contract, which the court found, which both courts found, General Sessions and Circuit. The situation that the court was asking about when he says that the proof was uncontroverted, actually was a great deal of proof that he was, in fact, capable of flying. He had flown within a couple of 3 days of his termination. He was not fired for performance. His performance, they testified, was good. He was a good pilot. He knew what he was doing. He had developed some discomfort in his back. he got into discussions with them about accommodations, and they apparently didn't like his attitude, and he didn't much like them either. And so it came to who was going to make the decision, and so they fired him. They discharged him. They had every right to do that. They had no cause to do that, but they had every right to do that, and they terminated it on the 20th. He was flying at that point. He had flown from April. The testimony was he'd flown from his first symptoms or his first problems. He had flown from April until September without incident, and as such was fully capable of flying. He was fully. Now let's all look at the wording that Mr. Ryan relies on, which is, I'm going out on workers' comp. Well, he's testified at various times that he thought he had to tell them that he was going to make his claim before he left their employment. He also testified he didn't know much about workers' comp. But at that point, he just made a statement. It's not a legal statement. He made an angry statement because he'd just been terminated and he didn't necessarily want to be terminated. The proof was totally controverted because my client got up and testified to that fact, and was what he basically said in both trials that he was ready, willing, and able to work, but that they didn't call him. And Mr. Turner said, I was not going to call him under any circumstances. He said that over and over again. So this whole thing that he was disabled the moment he made an angry response to being terminated is I don't think has a foundation. To say that the trial court wasn't clear, I turned to the same page Your Honor did of the ruling. This court made very detailed findings, and she specifically found that he was able to was able to fly and would have fulfilled his contract had he been given the opportunity to do so. I don't want to repeat things that have already been discussed. They're actually, I think if you want to get further down, he was found not to have a workers' comp injury. He was never disabled. Now, Dr. Merle said, look, until you get an MRI, you probably shouldn't fly. So he wrote that down. But that was 2 days before the 30 days ran. He had not prior to that had any effect, and it was never reported to the FAA. He didn't report it because he was not disabled. The AB Jets didn't report it because he was not disabled. This was an afterthought to avoid having to pay him this last 30 days of pay that he is entitled to receive. I have done this for a fair number of years, and I rarely ever file. I was only in on one other that I can remember in 40 years where I claimed something was a frivolous appeal. I believe this appeal is frivolous. Both judges found the same thing, that he was capable of flying. He was ready, willing, and able, that they weren't going to call him, that they did not call him to fly, and they owe him that $7,000, and that this appeal was just to delay him from collecting that one check. And I will end myself early and ask the court if the court has any questions of me.
Let me ask, at the trial court level, other than a reference to your client's statement about him going out on workers' comp, did the defendant put on any proof that he couldn't fly at the time of termination?
Pardon me, I didn't know you. No, sir, none, zero, nada. They didn't know. This didn't honestly come up until we tried it in general session.
I'm sorry, but I'm asking about the trial in circuit court.
Yes, sir.
What was the proof, if any, put on by the defendant that the plaintiff could not fly other than his statement saying, "I'm going out on workers' comp"?
There was no other proof.
Okay.
I don't want to take away from Mr. Caperton's opportunity to end early. Okay, thank you, Mr. Caperton. We'll hear from the appellant. I believe you have 3 minutes, Mr. Ryan.
Thank you, Your Honor. Whether Mr. Mahnken was a good pilot at some point in his career or whether he wasn't is of no consequence to the issue before the court.
Let me ask you a question. Could you respond to Judge Armstrong's question that he asked?
I was going to actually point him to the record. We relied on the medical records that we offered for Dr. Morell's statements that he was not released to full duty until October 30th, and Avijet's policy plus the FAA would not have, he wouldn't have been physically permitted to fly a commercial plane, not his own private plane, but a commercial plane with other human beings, with other cargo, until he was released at full duty. As far as a record where I can point to you, it is volume 2, record pages 43, 44. And the actual exhibits, if I can point those to you. Volume 1, record 65. Record page 65. I don't know what more proof you need other than his own doctor saying that he was not at full duty. And again, the analysis is, had he died at any point during that 30-day period, whether Avijet's was intending to pay him or not, it would have excused, they would have been excused the moment that he was unable to perform by virtue of death. The same with sickness or disability. The minute you're unable to perform because of sickness or disability in a personal services contract, the other party is excused. Whether the other party was going to pay you or not, you don't even get into the other party's head. You look at whether Mahnken on his side of the deal, Mr. Mahnken on his side of the deal could perform. So not only did he say he was going out, and whether he said it because of anger, whether he said it was for any other reason, that, and by the way, that was his first notice. The record is crystal clear. That was the first notice that he had ever given Avijet's of a back condition. But the moment he said that, under their policy, under the FAA, they're not going to let him fly until he's cleared by the doctor. Now, why he didn't get medical treatment sooner, that's on him. It's not on Avijet's. He wasn't able to physically perform during the relevant 30-day period. The medical proof shows that, Your Honors. Thank you very much.
All right. Thank you, sir. Gentlemen, thank you for your arguments. I appreciate your clients allowing us this opportunity to resolve this case by way of Zoom hearing. We will endeavor to get you an opinion at the earliest possible time. And I assume that concludes this matter. So Angie, if you will, if you'll recess court to the call of the next case. Thank you, gentlemen. Appreciate it.
This
Thank you.
honorable court is in recess until 11 a.m.